Yeah, I'll kick things off at noon. Hello, everybody. My name is Patrick K. Lin, and I am the Judith Bresler Fellow at the Center for Art Law. Welcome to our panel discussion today on posthumous art, law, and the art market. Our panelists, I want to first introduce everyone to the Center for Art Law and talk a bit about what we do here. The center is a Brooklyn-based research and education nonprofit dedicated to offering resources and programming to advance the arts and law community through our publications and events. We keep our audience updated on all things art law, including industry news, noteworthy publications, new deals and cases, and much more. The center also facilitates conversations with art and law professionals in our clinics, workshops, and of course, panel discussions like these. You can also subscribe to our newsletter to receive updates about the center's programming and art law news in general. We also invite you to become a premium member to receive discounts for our events and other perks, such as access to our case law corner and our archive of past events. Our next event this month is a workshop called Exploring Copyright Ownership, Works for Hire, and Generative AI. It'll be led by entertainment and intellectual property attorney Max Haas. You can register for this event through the center's event page. Now, without further ado, let me introduce you to all of our panelists today. First, we have Sharon Hecker. She's an art historian and curator specializing in modern contemporary Italian art. She trademarked the Hecker standard for due diligence on artworks and teaches courses on due diligence in art law, LLM, and master's programs in European universities. Peter Karol is professor of law and faculty director of the Franklin Pierce Center for Intellectual Property at the University of New Hampshire, Franklin Pierce School of Law. He focuses scholarship on intellectual property matters, specifically art, museum, copyright, and trademark law. Sharon Hecker and Peter Karol both co-edited Posthumous Art, Law, and the Market, which will be the book that we're discussing today. And then we also have Guy Rubb, who's a professor of law at Moritz College of Law at Ohio State. He's also an expert in the intersection between intellectual property law, commercial law, the arts, and economic theory. And Eva Subotnik, who is a professor of law and associate dean for faculty scholarship at St. John's School of Law, focused on issues of artistic intent that arise in the realm of copyright law and policy. Guy Rubb and Eva Subotnik both wrote chapters for posthumous art law and the art market. You can read their full bios and other articles and research that they've written in the past in the panel handout, which we'll include a link to in the chat. Thank you very much to all our panelists for joining us today. And with that, I want to first kick things off to, let me see. Oh, yeah. First, I want to start with Sharon Hecker and Peter Karol. So much of the book is focused on this kind of discussion around competing interests relating to art historians, the art market, the economics of art and art law. And I want to first start with both of your perspectives, as art historian and art lawyer, on how those competing interests impact posthumous art and the greater art market.
Yeah. Well, first, let me just start by saying, Patrick, and everyone at the Center for Art Law, thank you so much for inviting us here to talk today and talk about this volume, which just came out in a paperback edition. So we're very excited about it. And we felt like there were kind of so many interrelated issues that can arise when works are conceived as multiples, sculptures, etchings, prints, photographs, conceptual art, when they can be and often are remade from the original models and plans, long after the artist has passed. There are so many kind of examples here throughout in the book where there's so much variation, right? And both jurisdictional variation, which is kind of very much resisting all attempts at very generalization, but even like you said, with kind of across fields, whether it be art history, legal academy, economics, And the market, for example, often cares very little about what the law has to say. And of course, art historians, many of whom wrote for our book, often disagree strongly with what the law allows the states to do in many cases. So what you see throughout the book is this constant sort of, I don't want to say disagreement necessarily, but different views from different vantages. And, just to take one example of that sort of market doing things very differently from law, many of the listeners will be familiar with this case about Alexander Calder from the 1990s, when you had a judge in Washington, D.C., who basically sided with kind of a younger, less established expert who he found to be, really credible, and decided that this disputed mobile at issue, which was called Rio Negro, was likely genuine, albeit damaged. And the judge rejected sort of the contrary view of a very well-known expert, which some of you might know, named Klaus Perls, who was Calder's longtime U.S. gallerist. And he asserted the mobile was an inauthentic copy. And what result, of course, the judge says, the younger expert's right, this is authentic, and the market just doesn't care, right? And this work is essentially unsellable, and because it doesn't matter so much what the law says to the market. So that we see those kind of conflicts throughout the book, and throughout these kind of back and forth. So Sharon, do you want to
Sure.
add your art historical perspective?
Yes, we just thought we would start by telling you how the whole book came about. So I've been working on and writing about the question of posthumous casts in sculpture for a long time. And in 2018, I co-organized a conference at the Catalog Raisonné Scholars Association, where we wanted to invite art historians, lawyers, and art market people to present different case studies that had to do with sculpture that was made from original molds after the artist had died, and who was authorizing them, under whose authority, were there problems with these works for the market, for art history, for art law? And there was a lot of discussion around that. And we had actually looked online and found Peter Karol, and we had invited him to moderate a panel. And so that's how we met. And afterwards we thought, well, there's a book in here. We also noticed, as Peter was saying, this disconnect between art history, art law, and the market, how we all speak sort of different languages around the same thing. And we really thought, wouldn't it be great to bring together all three fields into the same book, and so they can talk to each other in this space. And this, we also thought, could help us broaden the whole reach of the idea of not just sculpture, but also photography, etching, anything that's inherently made in multiple from a matrix. So there's other practices you'll see in the book far beyond sculpture. Even performances, for example, that are redone after the artist has died.
Yeah, and I think, it's another related to exactly what Sharon's talking about. These different fields seem to only ever speak to each other when there are legal battles, so litigation, right? So we wanted to create this sort of network of relationships and open up new understandings, at all stages of the creation, distribution, collecting, showing posthumous art, rather than just at that litigation time. And we really encouraged our authors to sort of speak to each other and across disciplines. So you'll really see that, especially in our conversation today with Professors Rube and Subotnik, I'm sure, as well.
Yeah, we also asked our authors not to speak in a language that wouldn't be intelligible to the other fields. So we worked with everybody, because it gets very technical, and then you're only speaking to your own people. And just to give you guys a sense of what we're talking about, if posthumous art is something that's just fallen into your lap 5 minutes ago, what we put on the cover, there's a sculpture that is the original is right out, all of those, you guys who are in New York, the Statue of Liberty, and the one on Ellis Island, and that we know that was made in the 19th century by Bartholdi. But recently, long after there it is. Thank you. You can keep showing it, because otherwise they won't get what we're talking about. You can see that one in the far part of the image. But recently, century after the artist's death, 12 new casts were made using the original plaster models that is in a French museum. And so there you can kind of see Lady Liberty, the original, but you can also see her little sisters, and you can see that they're made out of different materials. They're completely different intentions. They might look identical until you start looking at them more carefully, because there's a lot of differences. And the question of who has the right to make more of these, and how posthumous art is made, like according to what criteria. Can present a lot of questions and challenges when you start getting into these deep questions. And then there's these very contentious words like, do we consider these things original because they come from the original molds? Can we consider them authentic? That's another very contentious word for art history. But the law will give different answers to that word. What is original and what is authentic? Do we just call them copies? How do we label them? What's their value on the market? And with respect to the original Statue of Liberty, and that was made under the artist's supervision during their life. And maybe did the artist care or want to have their works reproduced after they died? And also, does the public care at all? So these are some of the questions that came up over and over again in the volume. And what we learned is that the market sells them and the law sometimes protects them, but art historians might feel that they have just gotten very far from what the original idea of the artist was. And for example, we learned that appraisers in our book who wrote articles, they think there's a very good market for posthumous art. And you can see that in art fairs. I'm sitting here today in Art Basel, and I can tell you that there are posthumous works on stands. And I have vetted sculpture for fairs called TEFAF, where we have a lot of issues with posthumous casts, whether they're okay or not. We found that not everybody in the market is being transparent with their labels. So some collectors and museums and the general public just don't know the difference between a lifetime and a posthumous cast, while others, like collectors, can be very unhappy when they find out that there is a difference. And then there's others who just don't care at all. And there's lawsuits when you thought you bought something that was made under the artist in the artist's lifetime, but then you found out that it was actually cast by their child afterwards. If a posthumous work is on a dealer's stand at an art fair, the art historian might become very concerned that the work is just too far from the artist's vision. Like if you're the artist's daughter and one day you wake up and you decide to make your dad's work in blue or enlarged in size or without arms, what do you do with that? Is that okay? But at the same time, it's been legally made. The dealer would like to sell it. So you're stuck in this kind of situation where we don't have an answer. And in fact, we didn't try to answer that question in the book. We don't say who prevails in that case. Art historians would like these differences to be better defined so that there's more transparency. And they also want the stories to be told of how these works got made. So for example, I don't know if you guys followed the whole story of the Brancusi estate. We have a really interesting essay in our volume where many posthumous casts were made according to very different criteria than the way the artist worked. He used to hand polish his works. These are made by machines. And they were then put out on the market. And there is, again, a complex and interesting legal case where art historians have been working on for a long time about whether these are okay to call them Brancusis, because he was obsessed with the hand polishing of those works. Sometimes the artists weren't clear about their legacies. I mean, Henry Moore said, I don't want any posthumous casts, destroy all my molds when I die. But then we have artists who died very young or committed suicide and didn't give any information. And we're going to be talking about that in a minute, about when Eva comes to speak to us about that, what kind of legacy you want for your works, and you're not explicit. And then of course, because they're artists, sometimes they change their mind halfway through their life, and first they said no and then they said yes. So mostly we realize the fact that every artist is different and that it's really hard to generalize, and there's so many permutations on things that can go wrong, how relationships can go awry, that it makes it a very, very rich subject in a book. Technology is also a huge question, of course, because today we have 3D digital scans that look pretty damn good. And we can now look to see what's under paintings, like in X-rays by Picasso or Manet. And sometimes you find something the artist painted over, made a whole new posthumous work. And is it okay to bring those images out? We also talked a lot about other cultures, which for me was the most exciting part of the volume, and I think also for Peter, because in Michelangelo's time, copying had a completely different religious meaning, where you were touching the relic. It was like a relic, you were touching the master's hand. Or in Chinese art, where you take up the brush and you copy the master, it's a great act of respect and embodying the master's brush. or in Native American culture, which we found out in the volume, if you want to do a performance of your ancestor as a Native American, you have to carry with you the sadness of your ancestor's death with you as you make the posthumous performance. So it's really very different from the Western economic idea of posthumous casts being made mostly for the market and for spreading an artist's legacy. So Peter, do you want to tell a bit more?
Yeah, I mean, I think we're looking forward to kind of Professors Rube and Subotnik talking about this. I thought one last thing just to mention, you know, artists' intentions, as Sharon was saying, are not themselves consistent, and often not only do the artists change their mind, but you often have these kind of rich contests between what their intentions were, right? So people often talk about what was the artist's intentions, but of course everybody knows that's so contested. There's a great essay by Rosalind McKeever about Boccioni's futurist sculpture, Unique Forms of Continuity in Space. And he very much spoke, as is put out in the essay, disparagingly of using bronze as a material during his lifetime. And then you see after his death, the claimants to his legacy, specifically those who inherited the rights to the mold, on which they based the right to make the reproductions based on ownership of the mold, started talking about his preference and saying he had a preference for specific bronze alloys, right? And on that basis, then kind of went forward with various bronze casts. So you even see kind of this difference of what even the artist thought, often by as we go forward in life after death with those who survive.
Yeah, thank you very much, Sharon and Peter, for that introduction. I think, yeah, it's really interesting to sort of hear more about this tug of war kind of between, you know, artists' intentions and their instructions, and then how that kind of fares in the art market. And I think that also serves as a really great segue into, you know, Guy, your chapter. You know, you talk about the challenges of posthumous moral rights, and that concept really is non-existent in the U.S. In the U.S. legal framework. And so I want to better understand, you know, from your research, what sort of legal challenges or disputes arise with respect to moral rights, especially in the posthumous context.
All right. Thank you so much, and thank you, the center and everybody who joined today. So, you know, if we take a step back and try to understand what moral rights is all about. So when an artist creates art, they get three sets of rights. They get property rights, which we sometimes tend to ignore, but they're actually the most important one, right? That you own the piece of work and you get to sell it and you get to generate income from that piece of work. So that's really important. On the intangible side, you get two sets of rights. You get economic rights, which is the traditional copyright law, US copyright law right. You have the right to control the reproduction of the work. You have the right to control the adaptation of the work. And the rights that I'm going to talk about are the moral rights. And moral rights are rights that's supposed to protect the personality of the author. And there are some of it are dedicated by international law. So there are two types of moral rights that practically every country in the world provides. This is the right of attribution. That's basically, I have the right that my name will be on the art that I create, and that my name will not go on pieces of art that I didn't create. So that attribution. And maybe the more important of the two is the right of integrity, and that is the right to prevent certain modification of my work that are harmful to my reputation or my dignity. And this is the core moral rights that are required by international law, but many countries provide additional set of moral rights, like a right to prevent the destruction of my work, or the right to control when my work will become public, or when my work will stop to become public. So all those are the moral rights that we have. Now, the question is then, how do they work in the long run? And this is, as Patrick noted, where the United States have different approach than the European countries, the EU countries, and the United Kingdom. In the United States, we have a compromise that was reached in the late 80s. And that compromise, when we passed VERA, which is the main moral right federal law, we agreed that VERA will last only until the author dies. There are some exceptions to it. I will mention one of them in a second. But generally speaking, when the authors die, the moral rights are eliminated, are exhausted. However, we also decided that state, and we explicitly write it into the federal law, states are allowed to provide posthumous moral rights. When we passed that law in the late 80s, it became effective in 1990, we already have 5 states who have done that, and we basically federal. The Congress invited other states to join, but no one did. So we are still kept with those 5 states. The most important of them is California. In California, it's called CAPA. There is a right to sue by the heirs until life plus 70. However, it's almost not exercised. Those 5 state rights do exist. They are very, very few disputed. I found one dispute by actual heir, and in that dispute, this is actually one of the exceptions that could have sued by federal law, because this is one of those cases. One of the exceptions under federal law is if the artist is dead, but their co-creator are still alive, they can bring claim under VERA, and that was the case here. So the only case that we actually had the state law cause of action was actually a state law that was, it's sort of not a very interesting case. So in the United States, for the most part, put inside those tiny exceptions, the right dies when the author dies. In European countries, it's really different. Many European countries provide posthumous moral right for the life of the author plus 70 years. So it's basically the same as general copyright. While in some countries, France is the most notable example, Italy is another, the right don't expire. Moral right lasts forever and ever, at least in theory, in perpetuity. Which I think brings about the second question, okay, do they really last in perpetuity, and how do you handle rights that last that long? And that brings about, when you dig slightly deeper, you find out that European country actually scrutinized by courts the moral right quite heavily, and make sure that they don't really last, at least not in the same force forever and ever. So let's talk. I'll talk about the 2 main legal systems, Germany and France. In Germany, when moral right do expire 70 years after the author passed, after the artist passed, they applied this approach that's called balance of interest. They said, we are looking at all the interests that are relevant here, and we need to balance them. And the interest of the authors, there is case law in Germany that says that the interest of the artist are very, very strong when the artist is alive, because this is their personality, and we need to really preserve it. When they die, the interests are still there, but they are weaker. So suddenly you have to balance that versus the interest, and I'll talk about that in a little bit in more details, about the interest of the public and the interest of other people to use the work. And all those interests are slightly becoming more and more valuable. So the way that the German law perceives moral right, it's really weird, because this is not how we think about copyright generally, which we have a right, and the right sort of lasts as long as it does. And as long as it does, we just have the set of rights that we have. In Germany, the right maybe last that way when the artist is still alive. When they died until 70 years thereafter, the right sort of over time narrows sort of naturally, and eventually it expires. In France, they also have this somewhat similar approach. The most interesting case there. So in European country, unlike the United States, moral rights applies to all art, not just visual art. In the United States, moral rights apply to visual art, paintings, sculptures, graffiti, but not to plays or music instrument or any other type, movies. And in European country, moral rights apply to everything. So the most interesting case in that respect comes from France, and it has to do with Les Miserables, like Victor Hugo plays. And in the early 2000s, we are 136 years after Victor Hugo died, someone wants to create a sequel, to publish basically a sequel that describe what happened to some of the character after we left the story, the original Victor Hugo story. And Victor Hugo great-great-grandson has an issue with that. So they sue for moral right violation. And because, again, this is hundreds of years after the words was created, about 150 years, but they can do that. And what happened is they lost the case. And because the French court says, you know, this is so much, yeah, you have a right. The court started with every grandson can file a claim because you are all claimant after moral right that never expire. However, we will read the moral right more narrowly so long afterward. And in particular, once we pass that stage of last plus 70, once people are allowed to create modification, we are not going to let you stop every modification under a moral right claim. So we are going to be stingy. We are going to look very carefully, said, is it really that harmful to the author's, 200 years later, to the author reputation, to the author dignity, to the author personality? And the court says, well, rarely it does. So long after the author has died, and therefore they allow those sequels to come about. So the last part of my piece, and I want to talk about it for a few minutes now, is, okay, so does it make sense? Does it make sense to have so long moral right? And I'm thinking that we need to be slightly more careful. And we see the European courts who are, on one end, granting the right, on the other end, scrutinize them. And I think there are reasons to be slightly skeptical about moral right. And I want to mention 3 points here. One is that we need to be slightly worried about, after the authors died, about who is the claimant, who is the person who is entitled enough to tell us who can enforce the moral right. And the thing is that when the artist is alive, it's an easy question. The artist is the one that can protect their own personality. That makes sense. But over time, we start to have generation and generation later who might not know the artist, might not have never met the artist. And there are many of them. That's the problem. It's not just one person. They have, 3 children, 10 grandchildren, 30 grandchildren. And all of them are, in theory, claimant. And that creates a very difficult problem for us. For example, from the perspective of clearance of rights. So while we know that moral rights, usually you can't we can't transfer them, and they are not sellable, you can sell them to others. You can actually license them. European courts are very clear. If you want to authorize a very specific modification of your work, you, the artist, you can do that, okay? But what happens if the artist is dead, and we are now, 100 years later, 50 years later, and now there are 30 grandchildren. Do I need to get to talk with every one of them and says, are you okay with my modification? Because each one of you can sue me, right? So it makes the modification difficult. So it makes sense to weaken the right, because modification, otherwise we won't be able to do anything creative with the work. So this is something we call the tragedy of the anti-common, which means that there are so much ownership rights, and there are so many people who have ownership interest in the thing, because when it comes to physical work, it's actually pretty rare that over a generation we suddenly have 30 people who own that sculpture. It usually goes to a person or a small group of people. But with IP rights, it's very easy to have 30, 40, 50 claimants. And so we need to be careful. So that's problem number one. The second problem, and that's something that Eva is actually an expert on, that is a dead-end control. I think there is a bigger question if we take a step back and ask, is it justified? Even if you can't assess what the artist did want, we are 200 years later. Is it really what they want that should control what we do now? Should we let the dead control the living to that degree? Norm change, and what we did in the past and what we thought was acceptable 100 years ago, 150 years ago, maybe we have different norms nowadays. And so it creates a difficult question. There was a series of cases, again, not with visual art, it with Samuel Beckett, Waiting for Godot, that wonderful play. And the original play has 5 male actors. And modern creator wanted to have thought it would be very creative and very interesting and very modern to let female play some of those roles. And the Samuel Beckett estate sued them. They sued them and said, well, Samuel Beckett never authorized that, so how do he died in the 40s. So how do we know that it is okay now? And courts were all over the place. Some court says, yeah, you can't do that. That's Samuel Beckett never authorized that. He was very clear about his instruction who should play those roles. And some court says, well, over time, we don't think that we should let people control their work to that level of degree. So that's the second question. It's a difficult question. It's almost a philosophical question of who should control. Let me say one last thing, and which is, what about art preservation? Because that usually comes about. The idea is that, well, we start to have more right to idea of protect the personality and the honor and the dignity of the artist. But we have maybe a secondary goal, and that is the preservation of art that is part of our culture. And the example I'm thinking about here is the Notre Dame Cathedral and how we felt when it was burned. I was personally sad. I really was sad when I saw that fire. I mean, I don't have any property interest in Notre Dame. I don't own it. but it's part of our culture, right? Notre Dame has such an important Western culture, at least, right? Part of our culture, and when something that is so central to our life and our culture, we have sort of a public interest of not getting that destroyed and not getting that modified. And I think that's legitimate. That's a legitimate interest, but I don't think moral right is the solution to that problem, right? Moral rights are, first of all, if that's what we care about, moral rights should never expire. We should have it for always, and for maybe for all stuff, we should protect it even more. And if that's the case, then the state needs to protect it. I don't want the grandson of whoever was the architect of Notre Dame to tell me what we can and cannot do with that piece of culture, or grandson of Leonardo da Vinci tell me how to deal with their art. If their art is so important part of our culture, then the state should protect it. Maybe I'm okay with that. I'm just not sure that getting those grandchildren decide what to do with that 200 years later is the best solution. So yeah, it's not an easy area of the law. I will say the law is complicated, and the policy questions involved in that are not trivial either.
Yeah, thank you for that. I think something I want to return back to, Guy, is you talked about how courts have to sort of balance the rights of the artist and the rights of the public, and this inevitably involves the tastes and preferences of the public.
Yeah.
And the market. And I'm wondering, how do changing tastes on the art market impact those posthumous moral rights, and do courts have to kind of account for that in their own balancing?
Yeah, I think in those Samuel Beckett estate lawsuit, you saw court really struggle with that, with the waiting for Godot saying, is it okay now? Is what was the norm 50, 80 years ago? Do we want to enforce those norms nowadays? And I think there is, in my mind, and I think it's controversial. I don't think there is an easy, very clear right or wrong answer to this question. But in my mind, I think it's slightly tricky to enforce us to live by the norms of 200 years ago, or 100 years ago. And that's what we call dead control. This is letting the dead control the living. And I think it's a delicate balance, right? And I think Sharon also talked about the fact that at least you need to disclose that you are changing. People should know what they are getting. I think that's a fair point. But yeah, and this is where courts struggle with what to do with that. And the market struggle, right? We saw it with the Life of Washington mural, which was a big dispute on the West Coast about what to do with that mural that present views of slavery that many people find offensive nowadays. And other people thought, well, that actually represent what the artist's intent very clearly. And there was a big dispute whether we should cover that mural or not. Not so much legal dispute. The legal dispute was different questions about more of the administrative part of it. But it could have been a legal dispute about moral rights if we had posthumous moral right in the United States, about whether we are okay with covering art that we don't feel represent our values nowadays.
Yeah, no, thank you, Guy. And I think your points there really lead well into Eva, your chapter. You talk a lot about dead hand guidance and dead hand control, and really how there are a lot of shortcomings to dead hand control, and those instructions, right, that artists leave behind for their heirs and for the public to sort of really be attached to in that way. And so you propose this dead hand guidance approach, a different alternative approach to respecting an artist's instructions and how binding that should really be. And so, I'm wondering from your perspective, what can render dead hand control terms ineffective, and what makes dead hand guidance a better approach?
Well, let me just add my thanks for the opportunity to chat today. I think just to step back, we've talked a little bit about different bodies of law that can intersect, whether it's the laws in different countries or various laws even within a jurisdiction. And so in my work, what I have focused on is the kind of the intersection and potential conflict between state law provisions that generally guide succession law, right? The ability to leave one's estate according to one's choosing, versus federal law, the dictates of federal law in particular, as Guy has mentioned, right? Federal copyright law, which has its own policies that underpin its provisions. And so what do we do when these bodies of law intersect, potentially tug in different directions? And I just want to step back further and say that my research on these issues really showed two different things. One, not surprisingly, given the discussion so far, and by the way, it's really nice to be back in this conversation and to think and to remember, we wrote the book and the chapters several years ago, but really how much the chapters are in conversation with one another. So from one perspective, wanting more guidance from authors, absolutely, and artists, right? It's there's a lot of time and energy consumed with trying to recreate in good faith. What did this artist want? How should we piece together what they left behind? I wish I knew what they wanted. So, you know, a desire on that, from that perspective, to have those wishes articulated more clearly. And in the chapter that I wrote for the book, I put together a list of 4 organizations that I had come across in my research, sort of a cottage industry. I know there are more, basically trying to provide resources for artists to try to lay out their preferences so that when their successors come along, there is guidance, and that these issues have been thought through and there's something to refer to, and that's very helpful. On the other hand, right, we also have the perspective of the slippery slope. And once, you know, we're increasingly faced with the opportunity to check boxes online, right? And so the concern is, once you start articulating those preferences, is there going to be a temptation to try to make those preferences binding, right? Especially if various templates are put before you that suggest that you can make those choices binding. And I think that's really, that can lead to really problematic places, in particular because I think the overall thrust of copyright law can be different from the overall thrust of estate law, succession law, whatever you want to call it. In the latter category, succession law, estate law, what we're really trying to do is give effect to testamentary preferences by individuals, by artists, by whomever. We want to follow their lead because, among other things, we think that people will be more productive if they know that we will follow their wishes after their passing. From the perspective of copyright law to federal law, my perspective and what I've argued in the past in other works is that we don't want to be, and again, this touches on so much of what has already been said, but still, I think it's worth highlighting. We don't want to be in a position where there is literally no living stakeholder who is free to make decisions about the work. So, you know, if we are to give kind of ironclad backing to some binding instruction that an artist puts forward, right, then we have these instructions. The artist has now passed away. They have a successor, perhaps that successor, oftentimes it is an individual that owes a fiduciary duty, whether it's an executor or trustee. So now there are these binding instructions, and that fiduciary may feel bound to uphold those instructions. And so, you know, you have this body of law that, at least in the United States, is ultimately aimed to increase the production and dissemination and access ultimately to these cultural works. So what's sort of the implication where we would potentially give effect to binding instructions that means that there is no living stakeholder who can make unfettered decisions about the work? And I find that to be problematic when we're looking at the supremacy of a federal law, copyright law, as it is kind of intersecting again with these state law, these provisions that are backed by state law. And so in my work, what I've tried to point out, and this also dovetails on what Guy has been talking about earlier on, who are the stakeholders? What are the claims that they're likely to make? The problem, the legal issues that I foresee are, to the extent that you have a set of instructions that purports to be binding. Let's say that the fiduciary, whether it's an executor or a trustee, wants to comply, right? Wants to comply with those limits set forth by the artist. Well, they run the risk of a lawsuit, being on the receiving end of a lawsuit that would allege, among other things, that the assets are being wasted, right? That you have these valuable works of art and, or the associated IP rights. And these should be maximally exploited. And when the fiduciary is complying with these binding instructions, they might be accused of wasting the assets. And so that would be a very uncomfortable position for the fiduciary, even if they can point to the instructions that they have been given. On the flip side, what is potentially more likely, all of the stakeholders in the wake of an artist's death, right, the fiduciary and also the beneficiaries who are supposed to be reaping the financial rewards from the administration of these artistic properties in a trust, let's say, there's going to be incentives potentially for all of these stakeholders to want to just agree not to uphold the binding instructions, right? To allow the works of art to be maximally exploited, because that just makes more money for everyone. And if there's no threat of a lawsuit against the fiduciary, then potentially everyone, every living stakeholder benefits. So what I try to point out in our chapter in the book, in my chapter in this book, is just to say that binding instructions may conflict with federal copyright policy, are often not likely to be upheld, are often likely to give a false sense of security to an artist who thinks that they will be upheld, and are overall to be avoided. And instead, right, let's take advantage of all of the various sources of information that exist by institutions, organizations like yours, to encourage folks to set forth their preferences, right? Share that information, make it easier for your successors to have a chance to carry out your wishes, but really, really, really try to avoid the temptation to make those instructions binding. You asked a more, I think, specific question about, what would render an instruction enforceable or not enforceable. I don't have, again, so often there are not very many litigated cases that I could point to. In my prior work, I have looked at various examples and tried myself to come up with suggestions for future decisions, right, by courts. I think basically, in general, any attempt to bar kind of entire categories of uses of a work should be avoided, should potentially not be upheld. In particular, in situations where enforcement is not likely to lead to the preservation of a work. In other words, I can see, as Guy was finishing up his talk, we're talking about cultural preservation. We don't want to lead to a scenario in which artists are tempted to destroy their work because they see that their instructions are going to be fruitless. So we do want to give some incentive to folks to preserve, but where those incentives are not needed, I really think federal copyright policy should be interpreted and should be useful as a guide towards not enforcing overly onerous instructions by artists. So that's my long-winded answer to your question and a little bit about my work and my work on this chapter.
Yeah, thank you very much for sharing that. And I think that makes a lot of, dead hand control really restricts how an artist's work can be used by general public and can be, as you said, maximally exploited so that everyone can ultimately benefit from the art, being used in different ways. And, you allude to this a little bit, but I want to hear more about how those, binary testamentary instructions really run counter to the goals of copyright law and what relationship the fair use doctrine kind of has with respect to posthumous copyright.
Yeah, well, fair use has in the statutory hook 4 factors in a preamble that are looked to decide whether in any given circumstance the use of a work should be deemed fair. There's been a lot of talk about the fair use doctrine and how it should be interpreted in the wake of the Warhol decision from last term. A lot of concern that it has been narrowed, especially in the realm of the visual arts. And so, there has been in the past some explicit discussion by the Supreme Court that failure to license a work should not be outcome determinative for a fair use determination, right? The fact that you, as a user of a work, tried but failed to get a license to a work should not mean that your fair use claim is dead on arrival. And likewise, I would argue that just because an artist was extremely explicit about what they wanted to see happen with respect to their work of whatever form, visual art, literary property, whatever, I don't think that sort of very clear set of instructions or views or goals for the work should dictate a fair use dispute. I think the fair use dispute still has to wend its way through all the different considerations and factors. But it almost certainly can't be the case that an expression of desire or instruction that is made pursuant to state law regimes like succession law, estate law, that cannot be the last word on the interpretation of a federal statute and a federal policy of permitting fair use.
Yeah, okay. No, that makes a lot of sense. And I think that also leads to something that I really enjoyed about your chapter is that you open it up and you close it with this example of the Van Gogh immersive art experience. And I think for anyone who's on social media or especially those who are in New York, I'm sure you've seen advertisements for this and videos of people who've gone inside and it's this sort of digital art exhibit where Van Gogh's art is kind of recreated in this space where people can kind of walk through a bunch of screens that are showing Van Gogh's work. And you talk about how would Van Gogh have wanted his art to be shown in this way? What does this mean for the public that's consuming the art and ultimately appreciating it in this way? And I'm wondering how, going back to your sort of, guide and not bind approach to artists' well rights and copyright, how do these art experiences become more accessible to the public when you have a guide, not bind approach?
Yeah, well, I appreciate that prompt because it reminds me again of the context in which we were working on this book, right in the heart of the pandemic.
Yeah.
And going to the Van Gogh immersive experience was a highlight for me and my family after being cooped up at home for so long. And you definitely have the sense, and some of the critics and commentators, right, talking about theorizing that the artist would be rolling in their graves basically to see their work on display in such fashion. And so, I think, look, we know that the arts are now the technology, as Sharon was pointing out, right, is making these works so much more accessible in different ways, in ways that the original artist or the artist could never have imagined. And that's why I think it's really important to avoid trying in a binding way, right, to express your preferences and to assume that they would be upheld, or on the flip side, for successors to be bound by those instructions when there are vast opportunities to make work available in ways that literally were not imaginable when the works were created, or even when the artist passed away. So again, I think it comes down to where you have competing bodies of law, that to the extent that copyright law is organized around this principle of trying to make works of art, pieces that will enhance humankind, that people will have access to, that will enhance our knowledge base and our ability to respond to one another. I think that it's just really critical that we not overly bind ourselves, because there are these upsides to making the works more accessible, even if, right, some might not be thrilled with particular examples. And coming back full circle to what Sharon and Peter were talking about, the examples of the interplay between the art markets and art historians and the law. Different people are going to have different takes on this question. But from my vantage point, as being somebody who's focused on copyright law in particular, that's how I see things.
Great, thank you, Eva. And with that, I want to be able to wrap things up and move to our Q&A. But it sounds like this book really it takes a really interdisciplinary approach, and it sounds like at the end of the day, everyone has every field has its own sort of approach and appreciation for different aspects of the art market. But it seems like at the end of the day, if more consume and appreciate and engage with art, it becomes more publicly accessible. There's a lot of value in that, and I really appreciate it. This has been a really fun panel personally for me to prepare for, just because there's been so much and there's just interesting discourse in the book, and so I really want to link the book again. Here is a link to the book in the chat. You can also access the panel handout as well, which includes additional information about each of the panelists here today, as well as other works that they've done in the past. So thank you very much, Sharon, Peter, Guy, and Eva for being here today. And with that, I want to get into we're getting quite a few questions in the chat, and I want to be able to work through those. First, we have a question from the audience. For performance art, works that might not be designed to be reperformed in a way that, say, ballet is designed to be reperformed. Can you speak to any resources or examples that have set precedents?
So I can take that one, Patch. So as I understand the question, they're talking about performance pieces. I'm not sure what they mean by not being designed. So I guess like not one-time performances that are sort of not intended to be recreated. They're most of this would turn in the US at least on the question of copyright, right? Is this a copyrightable work, and is there in fact a copyright on it? And the reason I say that is because in a performance case, especially one that's not designed to be recreated, we have to worry about fixation, right? Was the original performance fixed in what we call a tangible medium of expression? That would be either sketched out in terms of what the various movements of the performance are, or recorded in real time with the consent of the artist creator. And if it was, then as long as it's made after 1978, then copyright would attach, and the ability to control what happens to that work going forward would simply be in the discretion of the copyright owner for the life of that original artist plus 70 years. And so sort of you wouldn't even have to turn to the moral right question so much if it is copyright protected, because that would essentially be a derivative work that was being then performed later on. So I think that's sort of the way that US courts at least would analyze that in the question. And probably the number one precedent in that space is the Martha Graham archive, where there was kind of a series of performances and dance. Obviously, these were meant to be reperformed, but the court looked to the fixation question, and they were fixed, and it became a real messy question of who owned those works. And that's really what the litigation was about.
Great, thank you, Peter. But the next question that we have in the chat, it's a long one, so I'll try to sort of summarize it. But the gist of it is, how do you all think that the difficulty in ascertaining an artist's original intent behind the creation of their work will shape moral rights litigation, especially posthumous moral rights litigation? And they've referenced the approach that the Supreme Court took in Warhol v. Goldsmith, and kind of how they ignored kind of the artist's intention there when creating the work, and kind of opted for more of a greater weight on the secondary use factor.
I can start with that. I mean, in the United States, that's a non-issue because we don't have
Right.
worldwide. In European countries, especially in France, it's very clear, in Germany almost, that the moral right protect the personality of the artist, not of the heirs. So if we know what the artist wanted, that is given weight. If we know this modification, the artist would have perceived this modification as harmful, but would not perceive that modification as harmful. If we can assess that, which is very difficult to assess, but then that is given the weight, and that's what needs to be balanced against the public interest, of course, right, as I mentioned. But that is, it's not what the heirs want or what the heir thinks is harmful to their reputation or the dignity of the artist. It's what the court assess, what the artist would have thought that is harmful to the dignity. And sometimes it's very unclear, in the Victor Hugo litigation, there are conflicting documents from his lifetime about how he felt about other people using his work. So it's slightly related to what Eva was saying about maybe they can tell us, but in many cases they don't. But in those cases in Europe, again, that issue doesn't arise in the United States. You basically bring an art historian and start to assess try to guess or to assess what the artist would have wanted again, and then you need to balance that against everything else.
Also, if you think back to, I'm sorry to go back to objects, but they're a little different from performances. In France in the 19th century, if you bought a sculpture from Rodin, you bought the right to do whatever you want with it. And then sculptors were not so happy with this because they had lost a lot of income as well. And so that's some of the reason that these laws became enacted to protect some of the widows, for example, to be able to make some money off of their husbands' molds after they died. But then that gave rise to a lot of sort of just the things that you guys were bringing up of sort of how far away are you getting from what they would have liked to do or what would be okay with them. I mean, we have letters from some artists saying, I don't want more than 4 casts made of this work, and there won't be I don't have the plaster mold anymore, so you can't make any more. But then all you have to do is take your bronze to a foundry and you can make another plaster mold from that bronze and go on. So anything that's inherently multiple, and then you really have to assess, do you think that this in some way disturbs what the artist would have been happy with or not? In the case of the artist I worked on, Medardo Rosso, he also gave plaster molds to friends saying, here, make some money off of this. I hope that you'll be able to cast as many as you want. I won't be around anymore. I don't care. But then later on, he became a lot more sort of worried about his future legacy. So again, you have to, and objects, it's very hard because in a market setting, when you're flooding a market with many kinds of objects, and they're could be kind of far away from what the artist wanted, then that is a bit problematic visually. And I know also, Peter, maybe you could talk for 1 minute about the Donald Judd situation, because that's another good example of sort of how far you can go, right?
Yeah, thanks, Sharon. I mean, so in the book, I have a chapter which we haven't really talked about today, but it's all about this concept of decommissioning artworks. And for those of you who are familiar with the Guggenheim collection, they have a whole collection from the work of the collector Giuseppe Panza, who had in his collection recreatable works by folks like Donald Judd and by Dan Flavin, for example, and some of these works that would kind of be taken apart and reassembled. Judd very much has strong feelings about whether they were properly in the collection based on sort of paper certificates that Panza had, and very much objected to people recreating them or recreating them in the manner that they'd be recreated because the plywood was subpar and that sort of thing. And after many, many years of study, the Guggenheim decided to what's called decommission these works and say, we're never going to remake these again. At least so long as somebody doesn't change their views later on. And so that was very, very much kind of a decision not based on the legal rights. The Guggenheim, I think most people agree, would have had the legal rights to recreate these works, but deferring instead to what they thought of as the artist's wishes, and Judd and Flavin specifically, of really not liking Panza very much later in their careers before they died, saying we don't want these works to be remade, and saying, you know what, we're going to defer to that ethical interest of the artist rather than the legal right of the Guggenheim to remake them.
Can I just add one last thought, because I know we're up against the hour, but I just want to point out that a lot of the issues that we're talking about, posthumous wishes of artists, are actually, at least if you look demographically, likely to be relevant while artists are still alive, as people are living longer. But losing potentially capacity at the end of their careers, their properties being managed by conservators or guardians. A lot of these decisions are going to be made while the artist is still alive. I was thinking about the word, it's not posthumous, but posthumous. I'm not sure what the word would be, but if you look at trans life expectancies, et cetera. So these are issues that may well be needing to be decided while somebody is still alive, but not in a position to make those decisions themselves. And if I may, I did just a tiny plug for work I just finished up with a co-author of mine named Andrew Gilden called Copyright's Capacity Gap. We engage with some of those questions that are very much, of a feather with everything that we've been talking about today.
Great, thank you. And I know we are just a little bit over time now. The last question I want to get to, a question for the audience, is someone is asking, what is the best approach for an artist to make their specific wishes known? Is it through estate planning documentation or certificates? But really, what is the best approach for making their wishes known?
Well, a lot of organizations have kind of boilerplate documents that can be used. And Patrick, are you going to be circulating the document of resources after this talk, or is it already out there? Because I'm happy to provide links to resources that I'm aware of.
Yeah, Eva, if there's additional resources that you want to share, please feel free to send it to me and I can circulate that. We'll also be emailing the handout to everyone, especially to those who couldn't attend today. So they will be sent out again.
Yeah, so I'm happy to provide some links, further links as well.
Great. Well, that wraps up all the questions that we have from the chat. And so again, Sharon, Peter, Guy, and Eva, thank you very much for joining us today and for all of your insight and walking us through sort of your thought process and research for the book, and for your respective chapters. And thank you to our audience for being here today and for asking those interesting questions. Yeah, this has been a really, really insightful and interesting conversation. So thank you.
Thank you.
Thanks for having us. It's a pleasure.
Thank you very much.
Great. Thank you, everyone. Have a good afternoon. Take care.
Bye.